me have a look. I call the honourable member David Clendon.
Tēnā koe, Mr Speaker. Thank you.
Had to make sure it was a green call, Mr Clendon.
Of course. Mr Speaker, I'm pleased to take a call on this Habeas Corpus Amendment Bill. The legislation deals with an issue with one of the fundamental cornerstones of our democracy, which is, of course, the right of a person not to be detained without due cause, to be brought before an appropriate judicial process sooner rather than later. And so any amendments, any consideration of these fundamental cornerstone, these issues of our core democracy ought not to be dealt with lightly or in any significant haste. When this bill was first proposed, of course, we were given some comfort by the fact that it was drawn from a Law Commission report some years previously. I think it was pointed out it was drawn virtually word for word, in fact, from that Law Commission report, which is not in itself a bad thing. The point was made, of course, and I think it's worth recalling that Mr Cheval, Charles Cheval, in the first reading of this legislation, did point out that perhaps it would have been an appropriate change, an appropriate amendment to be made by way of a government bill rather than a members' bill. Because after all, we've had this discussion earlier, members' days are primarily for allowing opposition parties and members to put legislation to the House when they don't have the avenue of the government bills being presented. I would, if I may, in passing, just to comment on Mr Cheval's imminent departure from the House. We regret that genuinely. He has been, in my experience, an extremely thoughtful, well-informed contributor to this House. He will be missed, and of course we the Greens wish him well in his new career. I would also add that given his imminent departure, I suspect his first reading, his speech in the first reading of this bill will go down in the record as his shortest ever contribution to this House, for reasons of his concern that, in his view, Members' Day was being abused in this way. Sir, it is in a sense a pleasure for the Greens to be able to support a justice bill coming from this side of the House, the other side of the House. Unfortunately, we seldom find much to enjoy or support when we see justice bills coming from the government. Democracy and justice seems to be issues that this government can take rather lightly. Now, we had this conversation last night, of course, in the context of the denial of the people of Canterbury of their right to vote for a period of some 9 years by the time they get to have a vote. We have seen examples, for example, a government, in fact a members' bill from a member of this government in the last term that denied all prisoners the right to vote by forcing them off the register of voters, which is an appalling misuse of the members' process and a very unfortunate outcome. So we could quote at some length a number of other issues that we have seen amendments we've made to justice, corrections, police, courts, which have not been desirable, which have not been helpful. So, as I say, we are quite pleased to be able to support this Habeas Corpus Amendment Bill. Sir, going to some of the detail, I didn't have the pleasure of sitting on the committee for the consideration of this bill, but it's clear that the committee has gone to quite reasonable lengths and given it a very thorough looking over, that appropriate attention has been paid to it. I'm just reminded from looking at my notes that when we first had a sight of this bill, we generally saw no harm in it and some potential good, but I was somewhat concerned by the reference to the use of video links and other technology, simply because in something as fundamental, as cornerstone as habeas corpus, I just had some reservations about the use of technology that might somehow prevent an individual literally being able to confront his accuser, which is the essence of the habeas corpus writ, of course. We're pleased to note that, in fact, in the deliberations of the Select Committee, they came to the conclusion that the existing legislation, the remote participation legislation that was passed...
Order. Can I just say to members, it's a long-standing convention of the House that members should not conduct conversations in the House unless it's necessary to do so, and then only so as not to disturb the proceedings. There's continual chatter going on, and I'm finding it difficult to hear what Mr Clendenin has to say. So I'd ask members, if they do want to have a private conversation, please do it outside the chamber. Thank you. Yes, courtesy is contagious.
Thank you, Mr Speaker. Something worth recalling. As I was saying, we were pleased to see that the Select Committee, in doing its work, was of a mind that the existing legislation, the Remote Participation Act, is adequate to cover the situations that might arise in the context of this, and so there was no necessity to include that. Well, the proposition is that clause should be deleted from the bill, and we're entirely in support of that. Another major clause, as has again been mentioned already, Clause 6, to clarifying that judges alone should have the right to allow other business to be prioritised ahead of applications for habeas corpus. And we think that's appropriate because this is a significant power that's been given. And I have to say, as having, if I may draw on some personal experience here, I had an unfortunate experience of what I can only describe as incompetence in the administration of a particular court. A minor matter, a traffic matter, that took 3 years to resolve, primarily because the administration of the Waitakere Court some years ago proved itself unable to correctly record my address. For that reason, that's a very personal and trivial reason perhaps, but more profoundly I do think that it should rest on the shoulders of judges and judges alone to make these decisions that potentially have significant consequences in terms of basic justice, basic democracy. We select our judges carefully. They are given significant responsibility. They are subject to requirements, accountability requirements, which is appropriate, but really we should leave these significant matters in their very capable care, I think. So there was also issue around timing, the proposition in the original drafting of the bill, that perhaps there could be an extension of time. This was again dropped, and I think it indicates that the Select Committee was quite thoughtful and careful in its work, that it worked its way through the legislation and looked at issues that perhaps, I dare say, it erred on the side of conservatism to make the fewest changes necessary to achieve the outcomes of this legislation. Because going back to the original purpose of it, it is clear that on occasion, albeit habeas corpus is an important matter, applications should always be taken seriously. But equally, there are other matters before the courts that are of significance, that are of importance, and where time is often of the essence. So allowing for this slight amendment, allowing for for a judge to make that call that a habeas corpus is not the most important issue to be considered on a given day, we think that is an appropriate move from there. So in summary then, I think there are, as I said, matters within this bill which ought to be treated seriously. It is a cornerstone issue. The Select Committee, I think, has done its work very diligently as well. It has applied sufficient time and thought to it. The amendments that have been made since the original drafting are amendments that we do think have improved the bill, which we supported at first reading. And so, of course, at this point, we're happy to continue to support this legislation through its further readings. Kia ora. Thank you, Mr Speaker.
Kia ora. I call the Honourable Member Alfred Nara.
Thank you, Mr Speaker. Mr Speaker, this habeas corpus amendment bill is a